their name, if they're worried about that, or changing to going off video. If that makes you more comfortable, please feel free to do so, whatever makes you feel comfortable while we are recording. And then I'm gonna go ahead and share my screen. And Alexandra and Shwali, for context, since everyone's muted, I'll just have to unmute you when I switch it to you, but didn't want you all to feel stuck or confused. All righty. Oh no. Okay, friends. All right, thank you all so much for joining us today for Knowing the New 9, a Q&A with Shwali Patel and Alexandra Brodsky. We're so excited to have our amazing friends joining us today to answer all your questions about the rule and make sure that as we're entering this really confusing period, folks feel equipped to advocate for survivors, feel that they know what's happening at their campus, and also it's really important that we know what the law is so that we can make sure to improve things in our school. While historically we viewed Title IX as a great tool to improve campus policies, I would say now it's a bit more figuring out how to get around Title IX to advocate for students' rights. And so while this training will look a bit different than typically how we've talked about Title IX in the past, it's still really essential that we know what's happening, what our rights are, so that we can really advocate for ourselves. So thank you all for joining. I am Sage and I run Know Your 9. We're a survivor and youth-led project of Advocates for Youth that is working to end sexual harassment and discrimination in education. Our team is built up of organizers and student survivors who are working in their community and nationally to end violence in schools. And we also have an amazing tier of student organizers called 9CAN that organize in their community to end violence in their school. I'll be talking a little bit more about different ways that you can get involved with Know Your 9, but I want to do a little bit of level setting about kind of what we're talking about today so that you all are able to ask the best questions possible. So first, I want to say that the rules for today are that only the trainers will be sharing our screens. This is just to make sure that we don't have anyone interrupting the experience today. Also, we love a lively chat. Feel free to ask questions, but we won't be tolerating any excessive profanity or abusive speech, and any of this will result in removal from the chat. So please make sure to be respectful when asking questions, and then we really appreciate back and forth banter, but do ask that everyone be respectful. And then this training is also being recorded. So like I said, if it makes you more comfortable to turn your video off or change your name, you're absolutely welcome to do so. And we'll be sharing this out with folks later so you can reference it and make sure that you all get all the answers to your questions. So first, let's do a brief breakdown of what is Title IX. Title IX is a federal civil rights law that prohibits discrimination on the basis of sex in education. And so Title IX covers a lot of different aspects of equity in education. It covers athletics, STEM, protection for pregnant and parenting students, and then also protections for survivors. Today, we're going to narrowly be focusing on the sexual harassment aspects of Title IX, and particularly the Title IX rule. So here's a couple things that we just wanted to lay out first of what's in the new rule. So under Title IX, in the new rule, schools must dismiss complaints of sexual misconduct that occur outside of a university program or activity. Colleges have to allow live cross-examination by the representative of each party. Also, they removed the 60-day timeline, so we're seeing a numerous amount of timelines coming forward from different institutions. While survivors were advocating for 60 to 90-day timelines, we're seeing something more like 150, or schools simply saying a reasonable timeline. If you and your perpetrator go to different schools that are not in a consortium, you can't pursue a case against them under Title IX. Under Title IX, schools can only investigate the most severe cases of sexual harassment. We'll talk a bit about more what that looks like. And religious schools can claim an exemption even after they're charged with discrimination. And also schools' obligation to act against sexual harassment has been greatly reduced. And so this is just a brief breakdown of kind of what's in the rule. If you want more concrete resources to use printout materials, feel free to check out knowyour9.org and our Hands Off 9 section. We have some great resources that you can utilize on your campus. And I also want to encourage folks today that if you are really interested in trying to bolster protections of student survivors in your state, that we're currently recruiting for our Know Your Nine ambassadors. And this program is a state-based program, and we're looking for students to work directly in their state with other student survivors and organizers to pass proactive policies that can support survivors in light of DeVos's Title IX rule. And so while we may have changes at the federal level, we also want to make sure that we're doing everything we can at the state level to really bolster protections for survivors and close some of these loopholes that DeVos has created. And so you can do this by going to our website and going to Hands Off 9, and you can apply to be a state ambassador with us today. So with that, I'm going to now just turn it over to Shawali and to Alexandra as we talk through some of the questions that you all had for today. And so I'm going to go ahead and unmute you all and then turn into the doc that we had. We've already gotten some questions submitted today, so we'll be going through the ones that we have first. But if you all have questions that are coming up, feel free to send those questions in the chat, and we'll be monitoring that as well to make sure that we get as many of your questions answered as we can. But I also want to say that Shawali and Alexandra don't have all the answers and don't have the answers for everything. This is a very confusing rule. It's still being developed as the department is continuing to release new blog posts that are changing even portions of the rules they laid forward. So if we don't have the answer for you today, we'll do our best, but keep in mind that we may not be able to answer all your questions. I also want to add that we're prioritizing students and advocates questions on these calls, and so probably will not be answering questions that are more looking to university compliance around the Title IX rule, but really focusing on questions from students and their advocates to make sure that they can be as safe as possible on campuses. So with that, I'm going to go ahead and unmute you all and ask you to introduce yourself if that's possible. All righty. Great. And Shawali, I'll have you start. Would you mind giving us a brief introduction of yourself?
Sure. Hi, everyone. I'm Shawali Patel. I use she, her pronouns, and I'm with the National Women's Law Center. I'm our Director of Justice for Student Survivors and Senior Counsel, where my work focuses on Title IX and addressing sexual harassment in schools, including K-12 and institutions of higher education, through litigation and federal and state policy, and education as well. I've been at NWLC for 2 years, and before then I was at Department of Education's Office for Civil Rights working on Title IX policy. I started during the last administration and left during the current one. I'm really excited to be here, and I hope I can be helpful.
Thank you so much, Shawali and Alexandra.
Hi, everyone. I'm Alexandra Brodsky. I'm a staff attorney at a legal advocacy organization called Public Justice. We're based in DC and Oakland, and we do a range of civil rights and consumer protection work. Most of my work is with our Student Civil Rights Project, though I also do some work around the criminalization of poverty. And I'm excited to be here with all of you today, though I wish that we were brought together by better news from the Department of Education. I also just want to apologize up front if you see me looking around. I'm not like texting a friend. I am a diabetic and I'm having a low blood sugar, so that is what you might see.
Thank you, and no worries. We really encourage everyone to do whatever they need to do to take care of themselves during this call. And we will be sending out this recording of the training later and resources with this. So if there are questions that come up about the slides or what we say in these trainings, everything will be shared with you all after as well. So I'm going to start with first question, which is, can you speak to the new clear and convincing standard in schools? How could survivors best work within this new standard, and kind of what sorts of documents or evidence should survivors maybe be thinking of if their school has raised the standard on their campus?
Sure, I'm happy to start off and Shawali jump in. I should say up front that Shawali and I are lawyers, but we're not going to be able to give you, individual legal advice today, but we can give sort of general guidance informed by the law. So I guess there's good news and bad news. So the bad news is that clear and convincing evidence is a higher standard than what most schools were doing previously. which was using the preponderance of the evidence standard. And this is going to be old news to a lot of you, but the preponderance basically means more likely than not. So if the evidence suggested that the allegation was probably true, the school would make a finding of responsibility. Now, clear and convincing is a higher standard. Courts don't put an exact number, 65% or something like that, but it's somewhere between the preponderance of the evidence and beyond a reasonable doubt, which is the standard that's used in criminal trials. And, I think that the good news is that as a student going through a disciplinary process, I don't think that really changes what you need to be doing, because your best bet was always to provide as much evidence as you had. I think that, to be frank, clear and convincing is going to be the biggest barrier for students who, like many survivors, have their main evidence is their story, and that's real evidence. Your experience about what happened to you is evidence. And when, under the preponderance of the evidence, if a survivor could provide their story and the alleged harasser had their story, and the school found the survivor's allegation more credible, that could be enough for a finding of responsibility. I think that's going to be harder under clear and convincing evidence. I'm not saying it's impossible, but I think it's going to be harder. I think that schools that use that standard are going to be looking for other forms of evidence to back up the survivor's account. So that might mean, text messages or emails from the harasser or from third parties who could say, hey, I saw you last night. You looked really upset right after you left so-and-so's room. Is everything okay? That can back up a story. But it will be, I guess the best advice I can give overall is to, the more you have that is in writing, the more you have friends who might not be witnesses to the harassment itself, but might be witnesses to how you were doing after the fact, as much as you can give to the school, I think the better.
Yeah, and can I just add something to it? Just, I think it's important to keep in mind that this rule now establishes that it is, you can provide any evidence they can consider that's relevant, but it is important to know that under the rule now, both parties would be able to inspect and review any evidence that's obtained as part of the investigation that's directly related to the allegations, including evidence that the school does not rely on in their investigation. So that's just something to know, that it would be, parties would be able to obtain that from each other. And I think we'll probably talk about this more just in terms of limitations that might come up during an investigation, especially in higher education. As you all know, one big change, or as you may have heard, one big change is that for higher ed, that parties would have to be subjected to direct live cross-examination, that a live hearing is required. But that, if there are any statements or evidence, and I know Sage had written a great op-ed about this particular specific issue, if a party, including the respondent or witnesses, do not subject themselves to direct cross-examination, only for institutions of higher ed that are required to have it, then the school wouldn't be able to consider any other written statements. So let's say it's like a text message from the respondent, maybe they admitted, maybe they apologized for what they did. If they're not going to participate in the live hearing, then the school won't be able to consider that evidence, unfortunately.
And I really appreciate you raising the point too, Shwali, on remembering that any evidence that you submit is going to be shared. This has been an issue that we've actually seen coming up really recently of when we've had survivors sharing information with their schools and their schools simply forwarding that information along and not considering that it could include the survivor's phone number that maybe they've changed trying to get away from an abuser, or it's included their address that their abuser didn't know and now has access to because they shared that evidence. And so Know Your 9 will be creating a resource for folks to think through what does safety planning look like with evidence sharing in this moment, because we do want to really ensure that folks are as safe as possible when thinking through what they're just sharing it as evidence and not intended to be legal advice, just meant to be in terms of like, this is a whole new ballpark that we're trying to think through. And so I really appreciate you sharing that, because that's definitely an issue that we're seeing coming up already.
One thing I just want to flag is that this is an area where the reg has a bunch of requirements and it's not really clear how they're going to play out in practice, and it could be different from school to school. So the reg says that any evidence that either party shares that is relevant to the allegation has to then be given to the other. But, you know, what's relevant is a big question. And so, you know, I think that, you know, I would make the argument that a survivor's home address is not relevant to the allegation. So, you know, one thing to maybe, if you're a student, to organize for your school to provide really clear guidance about, you know, what are they going to presume essentially is irrelevant. You know, we can imagine a circumstance where these pieces might come up, you know, if there are text messages that where it's disputed where the text message came from, they have to confirm, well, yes, this was, you know, one of the parties' phone numbers, you know, that might get tricky, but it would be great if your school could share some really clear guidance about what they are going to try to protect. And if you're thinking about reporting harassment to your school, you know, there might be an advocate or someone on campus who can help you figure out, if you move forward, what information is likely to become, you know, to be shared with the other party, so that you can make an informed decision about, frankly, whether, you know, that's worth it to you.
Absolutely. Thank you so much. So on to the next question, one we're getting fairly often is, what portions of the rule differ for K-12 students? And I know that's a fairly large question because there are some differences, but would love if you all could do a kind of a breakdown of what that looks like for K-12 students and what the difference is for college students.
I could get us started there. So there are a couple of differences for K-12 students, and so I guess two that I'm thinking of right now has to do with the notice and the actual knowledge provision, and then the other has to do with live hearing. So one significant change from the final rule is that it scales back on, at least for institutions of higher ed, who is considered to be what Department of Ed used to refer to a responsible employee. So an employee with the school who, once they're on notice of sexual harassment, has to do something with that report. They can't just ignore it. They would have to, you know, inform the Title IX coordinator. They have to take some action with it. For higher ed institutions, it's that person is only the Title IX coordinator or an individual with authority to institute corrective measures. So they don't specifically state who those specific individuals are, but they're usually someone who you would expect could be like a dean, or they're in a higher position at the institution. They wouldn't typically, though one could argue, you know, include a coach or a professor, an RA. For K-12 schools, however, there isn't that limitation for this employee. So any report that's made to any school employee, so this could be a bus driver, a teacher, anyone, really counts for Title IX purposes. So that means that that employee would have to do something with the report. They can't just ignore it. They would have to inform the Title IX coordinator, and some process would start from there. So that's one significant change, is the actual notice, actual knowledge, sorry, part of the rule. The other piece is live cross-examination, and I see that there's a question here, and I should have clarified. Parties can opt for an informal process that doesn't require direct live cross-examination, so I should have made that clarification, and thank you, Nadia, for that question. But in K-12 institutions, live cross-examination, live hearings are not required, but they are allowed. So schools could still allow for there to be a live hearing with direct live cross-examination. However, what is required is for there to be some sort of questions or ability for, after the investigation, for the parties to submit follow-up questions from the investigation to each other. So just to kind of backtrack to explain what this means is, so under the Title IX rule, there's basically two processes. For higher ed institutions, there's going to be an investigation, and after the investigation, there would be a live hearing for the formal process. And the live hearing would include cross-examination. For K-12 schools, there would be the investigation with the same requirements as there are for higher ed investigations, but it's not required that the investigation be followed by a live hearing. It could be followed by this written submission of questions. There might be other differences that I'm missing. Sure, Alexandra, if I know.
I think that those are the big ones. I think that there are parts of the rule that might end up playing out differently in higher ed versus K-12. So one thing that I've been worried about is this requirement that a school can generally only move forward with an investigation if there is a sort of written formal complaint. And let's be honest, that is going to be very hard for a 5-year-old to do. And I think that I'm hoping that we will see K-12 schools making accommodations to make that reporting process more accessible for kids who are literally just learning how to read and write, and also providing specific accommodations for students with disabilities and English language learners for whom that process will be more difficult. And I think we would argue that it would be unreasonable and unlawful for a K-12 school not to do those things. And for concerns that aren't specific to age for a higher ed institution as well.
Yeah, absolutely. And I think something that is important to know, or that we see a lot with K-12 schools, is that often schools are doing very little on sexual violence, or are doing nothing at all if they're doing anything. We also have seen often that schools will list Title IX coordinators, and you'll call their office and the person doesn't know that they're a Title IX coordinator. So I would say that, like, while these rules are worrisome for K-12 schools, I think there is still really a lot of space for growth and advocacy. And so if you're a high school student or a younger student that is looking to organize at your campus, please reach out to Know Your Nine. We have high school students on our team that are willing to work with you and organize for your campus, because I think that these rules are really worrisome for high school students. But I also would really encourage folks to use this as a moment to push your school to issue really strong policies when they maybe have never done anything on sexual misconduct in the past, and use this as an opportunity for further growth. So I'm seeing a lot of questions from folks. Oh, sorry, go ahead, Shwali.
Sorry, I wanted to add one caveat to the live hearing piece. So under the rule, actually, all colleges and universities would have to, under the formal process, have cross-examination live hearings. So this applies even if the complainant, even if the survivor is a K-12 student, and the assault occurred at an education program activity at the institution. So this could be a student who's taking courses at a community college, and they're in high school. And if the harassment or the assault occurred at the college, then they would have to participate in the live hearing if it's through a formal process, or someone who's participating in a summer camp that's hosted by a higher ed institution, and yet, they're a younger kid, they're in K-12, the same would apply to them. Kind of.
Yeah, absolutely, that's important. So a lot of questions that I'm seeing are about informal resolutions. And I think there's a lot of confusion around what could informal resolutions look like? What does this really mean? And so I'm wondering if you all could explain, first, are schools required to utilize informal resolutions, or is that an option under the rule? And then if a school does use an informal resolution, what could that look like?
So I think that the really key distinction here is whether there's any kind of sanction for the alleged harasser. So in order for a school to sanction a student who is, they have found to have committed sexual harassment within the definition that the reg provides, the school has to go through the formal process. However, the school can, as has always been the case, use non-punitive measures to make sure that the survivor can continue to learn. And so these have always been really important. And a lot of survivors, before this rule, and I'm sure after this rule, have gone to their school really seeking these kind of remedies specifically. So things like, moving dorms or changing course schedules so that, the survivor doesn't have to see their harasser in the hallway because they pass by each other every day. They don't have to share, so they don't have to share a lunch period, that kind of thing. The rule places some limitations on what schools, what kinds of non-punitive remedies schools can provide, because of their, the regs' insistence that the remedies not end up burdening the harasser, the alleged harasser unreasonably. And I think the truth is that, in principle, that's a fine idea, that if a remedy, if a quote unquote non-punitive remedy functioned actually to punish some, an alleged, a student who is alleged to have committed conduct where there hasn't been an investigation, that would be a problem. I'm worried that schools, because they have no idea what is, appropriately burdensome and not appropriately burdensome, will end up really limiting any kinds of remedies that put any kinds of restrictions on an alleged harasser. So for example, they will always require the, victim to move one way through a school hallway and let the alleged harasser sort of move wherever they want to. In terms of whether they have to, I think the answer is sort of yes and no. So the reg does require, as previous guidance documents did, the school to provide some kind of remedy to victims, or at least offer remedies to victims, but they don't specify exactly what those remedies have to be, and they don't have to be the remedy that the complainant asks for. And this is a place where the regulation using the new quote unquote deliberate indifference standard can be a problem, because the question stops being, did the school provide the right kinds of accommodations? And now the question will be, did the choices that the school made about how to support the victim, were those clearly unreasonable? And that's obviously just a work standard. This is another place where I think, the reg sets a floor, but it doesn't set a ceiling. And that's true with so much in this reg. And I want to be really clear about that all of the places where the reg says that a school doesn't have to do something, doesn't have to investigate off campus, doesn't have to investigate harassment that's not severe and pervasive, they can still do those things. And this is another case where your school can create a policy that commits to providing, really robust services and support measures for survivors. And that's a place where, frankly, student voices are going to be really important, because you're best positioned to, inform the school's choices about what will be useful to you and your classmates.
Absolutely, thank you. And on that, I'm wondering if you all could be able to talk a little bit about, one, like, what does this deliberate indifference piece kind of mean in terms of schools? What do students need to know about that when advocating for themselves? And then two, are there other laws or policies that students could use, like Clery, for an example, to rely on now, since Title IX is like a fairly weak tool to use?
So Alexandra kind of did mention this, that, the deliberate indifference standard applies to the school's response, whether or not they're moving forward with a formal investigation, or they're going through the informal process, or providing supportive measures to the student. So deliberate indifference, what it really translates into, it's clearly unreasonable, as opposed to what the earlier standard was, which is just, it was a reasonableness standard, right? So now there's kind of a lower threshold for schools in terms of, how, for lack of a better word, badly they can act, or ineffectively they can act in response to sexual harassment. But again, as Alexandra said, that's really just the floor. Schools can and should be doing a lot more to respond effectively to sexual harassment. And so in the preamble, which is thousands of pages or hundreds of pages, depending on which version of the rule you're reading, it does specify that a minimal and ineffective response constitutes deliberate indifference, regardless of whether it's a result of malice or incompetence by the school. So it's kind of some guidance that they provide, that it has to be more than something that's minimal or ineffective. And then I think Sage, you had asked about Clery or other laws. There are states as well, and maybe you'll be speaking to this later on stage, since Know Your Nine has been doing great work around this, is like the state advocacy. States have an important role as well in this, and that some of them do have laws that are protective of students and student survivors and can go above and beyond what the Title IX rules do provide for. So they're kind of another source, another resource. And I know with some of our groups, we're going to be doing more advocacy with states to ensure that they are, they have strong laws that protect students. Clery is another law as well that only applies to institutions of higher education. Thanks, Carrie, for noting that Clery requires reasonable accommodations. And Clery applies to sexual assault and dating violence, domestic violence, and sex-based harassment, among other types of what they call Clery offenses. And it requires the schools have policies addressing those like sexual violence, sexual assault, that call for I think prompt and fair resolutions of complaints. And so it does have some requirements. It's not nearly as detailed as the Title IX rule, but I think with older versions of the Title IX guidance that are no longer in effect, unfortunately, there was more like consistency between Clery and Title IX because there is overlap on the issues they address.
I would also flag that disability discrimination laws may be helpful for student survivors in accessing accommodations. That may require a student to get a diagnosis that, for example, they have post-traumatic stress disorder as a result of the harassment. But the Department of Education hasn't, or I won't even get into what they're doing with disability discrimination law, but I will say that there are other laws that may be, more powerful in that instance to say, in order to stay in school, you need to accommodate my disability that, happens to derive from the sexual harassment, but which I'm demanding rights, I'm demanding accommodations for as a student with disabilities rather than as a, complainant in a sexual harassment proceeding.
Absolutely. And over the next month, Know Your Nine will be creating resources for students and advocates to utilize just to back up these things that you need. So what under Clery can you use to try to say that you need accommodations? What a Clery can you use to force your school to do an investigation? And what are disability laws that you can utilize? What are state laws that you can utilize? Because while we recognize that student advocacy is really important, it's often helpful to be able to point to something else to tell your school you have to do this instead of saying you should do this. And so we'll be outlining spaces in which there are laws that folks can point to show what their schools have to do, and then also outlining what student advocacy should push for that schools should do. And that's going to be really important for students moving forward. And so stay tuned as we're releasing these resources for folks. I want to say that we have a huge library of resources that are now, in light of the rule, needing a slight revision and also needing to fill some gaps. And so we'll be sending those out slowly throughout the month to make sure that you all have what you need to advocate for yourself or advocate for the survivors that you work with in your school.
Can I add something to that, Sage, about Clery? Clery does have language about policies needing to consider the safety of victims. I don't know exactly how they phrase it, but I think that's really important to advocate that your schools are trauma-informed, for example, in their responses. I know there's been some pushback from the other side about trauma-informed investigations and responses, but I think there is, language in there that can be supportive of having responses that do consider, what type of, supportive measures are effective to protect safety, and also, schools just being trauma informed in general when they respond, and having policies around that.
Absolutely. And on that note, I'm wondering if we had a question earlier about if there is accommodations that folks could ask for related to disability reasons during cross-exams, since often the cross-examination process might not be accessible to folks with disabilities. And from my reading of the rule, they didn't seem to acknowledge that or recognize that at all, but we're wondering if you all had thoughts or different ideas of what folks can maybe ask for in terms of accommodations.
I think that's a great question. So the regulations require at higher ed institutions for there to be cross-examination done by representatives by the parties, but give schools a little bit of flexibility in what that might look like. So for example, not everyone has to be in the same room. The cross-examination can happen via Zoom or other video conferencing with everyone in different spaces, which could potentially be less traumatizing. And I think that there are, for example, the school should certainly be providing services for students who are hard of hearing or deaf, who might not speak the school's primary language as their primary language. I think that there are many accommodations that schools not just should, but must provide. I think that the hardest question for me is, let's say a student has been diagnosed with post-traumatic stress disorder that is triggered by seeing their harasser. It is difficult, I don't know that, I think schools are going to struggle. I'm not saying that they can't, but I think that schools are going to struggle to figure out how to comply with the rule and comply with disability discrimination law. Now, the answer might be that actually disability discrimination law just trumps the rule. If there's genuinely no way that they can comply with both. It's also not obvious to me that the school couldn't say that both of the parties have to be, when they're not being questioned, that they have to be outside of the scope of the camera. I think that there will be, I feel about this the way that I feel about a lot of things with this rule, is that there's room for schools that are trying to do the right thing, but the department is not going to make them do so.
And I think that last thing you said is really essential, because if schools want to do the right thing, they have some space to do that. And we've been working with students across the country to really push for better policies under Title IX. But like all students really know that often what schools say they're going to do on paper versus what they do in reality are very, very different. And that's really where student organizing and advocacy has to come in. And so I say that to say, like, while we're working through this to understand what the law is and what's in it, we shouldn't be confined to that. And we shouldn't just be stuck with this. We should use this as the floor and try to figure out creative ways to build out new protections and creative ways to get around pieces. And so on that, I'm wondering.
Can I just flag one really quick thing, Faye? Sorry, yes, that very quickly. I just want to flag that every state has a protection and advocacy organization that advocates for people with disabilities. And so it is incredibly hard to find a pro bono Title IX attorney, but it might be easier to find legal services related to disability.
That's a great flag. Thank you so much. That's really, really great. We had a previous question that asked, what could survivors and advocates do to continue organizing to strengthen protections for survivors in this moment?
I always unmute and mute myself at the wrong time. There are a few things. I think, again, going back to, where the rule sets a floor, and those places being an opportunity for where you can do more advocacy with your school and tell them it's not only something they can do, but something that they should do, is to do more to protect student survivors and to ensure that access to education is not lost. So, for example, one way of doing this is through the supportive measures. The rule really only mandates that school provides supportive measures for harassment that meets their narrow definition or that occurs within an education program activity as they define it in the rule. Schools are not prohibited from providing supportive measures to any survivor, to any complainant who has experienced sexual harassment, and they should be. And so I think that's one area where students can be advocating with their schools to ensure that every survivor, every complainant has supportive measures, and that the school is interpreting, while there is some limitation, the rule says they have to be non-punitive or disciplinary, that they are interpreting it as broadly as they can under, even under what's allowed or seems to be allowed under the preamble, so that schools are not, not providing supportive measures because they think they can. So for example, changing classrooms assignments when they can do that, in some situations where it wouldn't be considered necessarily disciplinary, or to the extent they can, to issue, a no contact order, one-way no contact order, as opposed to a mutual no contact order. Another piece would be around actual knowledge and notice. This is what we mentioned earlier about how now for institutions of higher education, only a report made to a Title IX coordinator or an individual with authority to institute corrective measures kind of counts for purposes of Title IX, where only those individuals would actually have to do something with the report, whereas every other school employee could just ignore known sexual harassment assault. So here is also another opportunity to ensure that schools are encouraging employees to, while having confidential reporting mechanisms like their school counselors, for example, still training their employees to respond appropriately and effectively to sexual harassment. Even if they're a professor and they're not an individual with authority to institute corrective measures. And then the other piece, and this is also discussed, I won't go into too much detail, is to still advocate and ask for schools to respond to sexual harassment that doesn't meet their narrow definition of severe, pervasive, and objectively offensive, so that it equally denies access to education, but that they respond to all sexual harassment, regardless of whether or not it occurs in the education program or activity, because the Department of Education has said over and over, and it's in the rule, schools can still respond to sexual harassment even if it doesn't kind of fall under the Title IX rule.
Awesome. And I would also say that Know Your Nine has a petition that you all can utilize for your individual school that outlines where schools have this version of MAIS that they can push for. And so feel free to launch your own petition. And we've seen a lot of schools issuing interim policies. And I also would say that, like, even if your school has released their policy or their final policy, like, policies are living, breathing documents that can always change. And just because they've issued it already doesn't mean that you can't push them to change it. And so I think that there's still opportunities to organize around that. And so please check out our website. In the Hands Off 9 section, it has the petition that you can use for your school, and then also the state opportunities to join and organize. So a bit of a technical question that we've gotten and that we were all talking about earlier is, if there is let's say a form of violence that is happening both within a school program or activity and outside of it. So take, for example, a student is experiencing intimate partner violence where they've experienced a fair amount of violence in their home, but also experienced an assault on campus one time. Would the school have to investigate that through two separate processes for the violence that happens on campus versus the violence that happens off campus? And then also, how does that impact that being utilized in evidence? I think it's fairly confusing, but would love for y'all to break that down a bit.
So, behind the scenes, we all have been trying to figure this out because this is a good and hard question. And I think, frankly, a question that highlights the department maybe didn't really think through the implications of all the decisions they were making. But so here's our best understanding. Our best understanding is that if there is a pattern of harassment or abuse that occurs both on campus and off campus, and when I say off campus, I mean sort of outside of, not in a different physical location that the school has some control over, like a school recognized frat or something like that. So happens on campus and off campus. We think that the school could just investigate all of those together. Remember, there's nothing stopping schools from doing, better than the reg requires when it comes to these kind of definitional issues. So they could investigate it all together. They could only investigate the harassment that happened on campus and choose to ignore the harassment that happened off campus. They could also pursue two different investigations at the same time. So I guess, silver lining of having such a narrow definition of sexual harassment is that for misconduct that falls outside of the rules definition, the school doesn't have to use the sort of scary process that the reg lays out. So theoretically, the school could, let's say that there are two sexual assaults. They could say, for the sexual assault that happened on campus, if you want to move forward with an investigation, there's going to have to be cross-examination. but we can at the same time or instead investigate the assault that happened off campus and use a different process that doesn't involve, you being directly questioned. I think that that's going to be a choice that schools are going to make individually. I really hope that a school wouldn't say that they're going to draw a really strict geographic line when there's a pattern of harassment, but I think that the rule probably allows them to do so. One idea that was floated behind the scenes, which I think is really smart, is that potentially, although the school could not punish someone for harassment that happened off campus without going through the sort of scary reg process, they might be able to consider that that abuse as evidence that confirms that a different, like a student conduct investigation. That wasn't very clear. Basically, it is plausible that even if there is, let's make this concrete, a school says we do not look at off-campus harassment, period. That is not within, that is not something that we're going to discipline students for. A complainant might nonetheless be able to say, I know you're not going to punish my assailant for what they did to me across the street from campus, but knowing about that might provide evidence that supports my complaint, that makes my complaint more credible, because it sort of shows that this person does this kind of thing. I don't feel 100% confident that schools will allow that. I don't feel 100% confident that the reg will allow it, but it's something that might be worth looking into.
Absolutely, thank you. And I think it's a great point of like, the more that we read into the rule and folks that work with survivors know what these cases look like, know what folks are experiencing, it's clear to see that the department didn't quite grasp the experiences of survivors when writing the rule and thinking through these unintended consequences that could come up. So I'm going to float. I know that Shwali and Alexandra need to hop off at 5, so I'm leaving some questions that I am able to answer as myself towards the end, to make sure that they can often prioritize in the questions that I do not have the answers for before they have to leave. So a first question is, what does the rule mean for folks that reported prior to its enforcement date and prior to August 14th? What do students need to know about that enforcement day and what it means for their case in their school?
So the Department of Education, kind of going back to Sage's point about how they're realizing as folks are asking questions that there are a lot of, the rules are confusing. There are a lot of questions, and we're trying our best to answer them, but I think there still is, and there's still a lot of unanswered questions, and that just kind of indicates how much this wasn't thought through by the department. But they had issued a blog post on August 5th, 2 weeks ago. So I don't know if everyone follows their blog, but at OCR, the Department of Education's Office for Civil Rights has a blog post where they've been kind of now posting some updates to the rule and some webinars as well, explaining the Title IX rule. But in that blog post, they said that the rule is not retroactive, in that if a student or an employee, a school employee, was sexually harassed or assaulted before August 14, 2020, which is the effective date of the rule, then the school is not bound by the Title IX rule when processing their complaint. That doesn't mean the school doesn't have to comply with the Title IX rule, and I don't, hopefully they wouldn't, but at that point, at August 5th, schools have already been making changes to their policies, given that they were less than 2 weeks away to the effective date of the rule. So that's what we have. That's what we know from the department. The blog post notably doesn't refer to any guidance. So, let's say there was an assault that occurred in 2016, and at the time, the 2011 and 2014 Dear Colleague letters were in effect. I don't think from the department's post, if that means that the guidance then would apply to harassment that occurred then if a complaint is filed later. They only cite to the regulation and the statute. Hopefully my response made sense. Let's clarify.
Yeah, I mean, I think that really what we're saying is that the department has created just this wild gray area of murkiness surrounding any violence that's happened before August 14th and what schools will do. Right now, Know Your Nine is drafting a letter for students and advocates to utilize if you experience violence before August 14th and you report it, to say, here's what the department says, here's what you should use. We can't say that like this letter is going to change people's lives, but it's what we're able to provide in this interim, that it is a really confusing process. And we've even heard from students that experience violence or in the middle of their reporting process, and the school immediately changed their process halfway through. So it's a bit confusing in terms of what that's going to mean, and especially frustrating that the department is clarifying these things through blog posts as if that's how we do law now. But one of the last questions that I really want to get to y'all is, what does, two questions. One, what does the rule mean for folks that are facing discrimination based on gender identity? I think there's a lot of confusion surrounding how the rule is going to apply to folks that are facing discrimination, that especially with new decisions by the courts. Do either of you have an answer for that?
So here's my read, and Shwali, tell me if you think that this is wrong. So as of 2 months ago, the Department of Education thought that Title IX did not protect students who were discriminated against on the basis of gender identity. That was their position. The Supreme Court recently said that an analogous law that applies in the employment context protects trans employees and queer employees from discrimination. And I think that the assumption, which I think is right, is that that would apply equally to Title IX. And that means that the department was wrong, and that Title IX does protect students discriminated against on the basis of gender identity. I think, and this is where I'm curious, Shwali, what you think, I don't think that this rule applies to harassment that is not sexual harassment. And I think that we can all recognize that, like, it is obviously both true that trans students can be sexually harassed, and then that harassment this reg would apply to that harassment. But if someone is being harassed based on their gender identity in a quote unquote non-sexual way, I don't think that these regulations would apply. Is that your read, Shwali?
That is interesting. So that's my read, and I was just having this conversation right before this webinar with with some other attorneys that do compliance work, where they were having the opposite read, or I think we all kind of had questions, because my read was always exactly what you said, Alexandra, that it would fall under the other part of the reg, 106.8, that calls for schools to have prompt and equitable grievance procedures, right? But that's it. It doesn't have, it's not the new Title IX rule. It doesn't have all these other requirements that the Title IX rule does that applies to sexual harassment. So that's my read. I think, I've also have received questions from a school that had a question about that and what that means for their policies. So I think this is another opportunity for advocacy from students to ensure that schools recognize that discrimination based on gender identity or sexual orientation is sex discrimination prohibited under Title IX, but that harassment or that type of discrimination doesn't fall under the new Title IX rule. And I think there's a very strong argument for why it wouldn't, that it doesn't include, that the new Title IX rule doesn't apply to all forms of sex-based discrimination, that it really just applies to sexual harassment.
Thank you. And then last question is in y'all's way. I see that the rule says that folks could delay for law enforcement investigations. Do you have a concept of like what that would look like in practice for students that maybe are having to, or reporting to law enforcement, or for folks that are minors and maybe are not choosing to report to law enforcement, but are in fact the school's required to report that to law enforcement?
I'm happy to sort of, again, share my read, and Shwali, tell me if you think this is wrong or right. I mean, the reg is not super clear about this. I think what is probably right is that if a school, if there is a concurrent police investigation to a school investigation, and the police say, can you hold off 3 days before interviewing this witness because we want to interview that person first, that the school would be allowed to say, or have to say, sure. What I feel strongly is not the case is that a school can say, until this criminal investigation and prosecution is over, we're not going to do anything. Shawali, is that your sense?
I think that's how it should be. Well, it should never be delayed for law enforcement investigation. Title IX is a completely separate process. It's a civil rights law, has nothing to do with the criminal process. And unfortunately, the reality is, and I feel like we especially see this in K-12, schools do delay, and they do think that they need to put it on pause and wait until a law enforcement investigation is completed, which can take months to years. Schools really are the ones in the best position to protect a student's access to education by providing supportive measures and accommodations, whereas that's not provided through the criminal process. So my read of the rule, and I don't recall what it says in the preamble. I haven't read all couple thousand pages if there is more nuance here, but that it does allow for delay, which we're very concerned about because of what we know has been happening pre-Title IX rule. Schools have been delaying when they shouldn't have, and that this will just allow this to happen, and more schools will be doing it. I don't think that the delay is okay. So the delay would be temporary. Getting messy, but I agree with you that it wouldn't blast through the entire investigation. It's just not clear how long it's supposed to last, and I don't know if school administrators are always going to interpret it in the right way. It is supposed to be a temporary delay, and I think this is another area where there could be advocacy from students to ensure that schools are very much aware of what the distinction is between like a temporary delay versus like a permanent delay, that waits until like the entire investigation by law enforcement is concluded.
Absolutely. Well, I want to thank you both so much for joining today. I'm going to stay on to answer a couple more questions for folks that I'm able to, but thank you, Shawali and Alexandra, for sharing your wisdom with us. I know this rule is complicated and confusing, and really appreciate all of your insight that you're able to share with folks as they're trying to advocate for themselves and their rights.
Good luck to everyone. Hope to talk soon.
Yeah, good luck. Thank you so much for having us.
Thank you. Okay, for folks that are able to stay on, I'm going to zoom through a couple more questions for y'all to make sure that we get as many of your questions answered as possible. So first, I see a question here of how can we make it clear that schools providing supportive measures to survivors doesn't mean that they have to provide them to respondents or perpetrators. And so first I want to say that the rule does say that schools need to provide accommodations or the opportunity for accommodations to complainants and respondents or survivors and perpetrators. We use complainant and respondent language. That doesn't mean though that if a survivor gets an accommodation that the respondent has to get the same, but there does need to be the opportunity for both. And so I think making it really clear to schools that the opportunity has to exist, but that doesn't mean that throughout the entire process they have to be exactly equal. So if a survivor gets access to counseling, that doesn't mean that the respondent automatically has to get counseling, if that makes sense. But if they request it, they can have access to it as well. What can happen when state laws conflict with with Title IX? And so I think that this is a bit confusing for folks and important to read. So when the rule is in direct conflict with the state law, so let's say the state law says you cannot use cross-examination in any form of investigation within schools, then when using a Title IX process, they would have to utilize the Title IX piece and not the state law piece. If they're doing something outside of Title IX, they can use the state law. So it's really about presumptions. Like the Title IX rule is always first when there's a conflict, but if there's not, they can follow the state law. And so I would really encourage folks to reach out to their local advocacy organizations or state coalitions to break down kind of like where are those conflicts and where are they not. If you have a specific question about your state, feel free to reach out to us at info@knowyour9.org. And then also just Clery apply to all colleges. I will say I am not a Clery expert. To my knowledge, Clery applies to colleges that get any federal funding. The same with Title IX, but if someone else is a Clery expert in the chat and wants to add that in if I'm wrong, Thank you. I really appreciate that, Lisa. Can punitive discipline be enforced through informal resolutions, or are you required to go through cross if you want it? So punitive measures can be enforced through informal resolutions. Both parties will have to agree to that at the beginning, know what's on the table, and both parties can back out at any time in those informal resolution processes. So someone could agree, they're waiving, when engaging in an informal resolution, you're pretty much waiving your right to cross-examination. You're waiving your right to those things that went around with that Title IX process and engaging in this process. So that means that you can issue punitive measures through that. I've also been seeing a lot of questions about informal resolutions, and so I want to dive into that a bit. So schools are not required to provide informal resolutions. That is an option. They can provide informal resolutions, and both parties have to agree to that. So that means that some folks have been advocating for their schools not to have informal resolutions. We've seen that a lot at schools that are religious institutions, where schools have used either religion to be manipulative in the past, or schools that have a long history of really sweeping violence under the rug or not favoring survivors. We've seen survivors say, no, we don't want informal resolutions at our school. We know that our institution just uses these manipulative tactics and we don't want them present. At other schools, we've seen folks say that we want some type of option for restorative justice. In those cases, we would really push for folks to advocate for a restorative justice process outside of your school, meaning having an MOU with legal crisis centers, having an MOU with restorative justice providers, so that you can make sure that your school is like really not co-opting restorative justice. I think what's been the most frustrating for me as someone that is really interested in RJ, and also as Know Your Nine's trying to honor the Indigenous folks and Black women that really built restorative justice and the processes that go around it, is seeing schools that have taken restorative justice processes and really just run with them and made them, or putting RJ on something that is just shuttle mediation, which is what we would see in like civil court. And so we really encourage folks that are looking for their school to utilize restorative justice to see if there's a way to contract with an RJ provider so that the school is in control of that scenario and can really honor a restorative practice so that you get what you need in that process, but also you can utilize it through your school. And to confirm, schools can only offer an informal resolution option when and after a formal complaint has been filed. Correct, Lisa. And what's the difference between punitive measures and sanctions? So punitive sanctions would be like a suspension, an expulsion, and non-punitive thing could be someone taking like a class on violence, or needing to write a letter, something like that. I will say that like one that we've seen in the past that are pretty worrisome is when schools have said like they ask respondents to go do community service hours, like a rape crisis center. If you're a student advocate, I would encourage your school to not utilize an informal resolution to like make respondents do community service hours with survivors. That's a wild thing that we've seen schools do and quite icky. Okay, must schools give complaints and respondents equal resources? So like I said, they have to give them access to equal resources. That doesn't mean that if one party gets access to a resource, they have to give the exact same thing to someone else, like counseling or like additional accommodations. It has to do if they have the opportunity to provide it, it has to be the opportunity to provide it to the other. Okay, how is evidence used during an informal process? And so during an informal process, you're not having to do the same thing of like improving that violence occurred. An informal process is two parties working together to come to an agreement on what the sanction will be. So that could be the school saying, you know, we've talked through this, we have decided that we're going to issue a suspension because the survivor, to continue their education, their safety, you need to not be here for 2 semesters. And so it's a bit different. And on the piece of clarifying, an RJ provider can utilize certain informal resolution. So I would say that like you could work with us to find an outside RJ facilitator. I think that there's many great orgs doing this. I would say that like Know Your Nine's knowledge of restorative justice is like this large compared to the vast knowledge that there is around RJ. So we're happy to find connections for you, but don't have like a quick and easy way to find an RJ facilitator in your area. Okay. Are there resources for survivors, advisors on what to do during live cross-examination? So in the coming month, Know Your Nine will be working with some lawyers to try to draft some tips and tricks on if you're representing someone through cross-examination. We recognize that a lot of survivors' friends or student advocates now may be filling this role of providing cross-examination when that's something that you never thought you were going to have to do before. And we want to make sure that folks are able to do that well and are able to support each other through that process. And so we'll be creating a guide for folks to use on how to engage in cross-examination, what are things to consider, that will also exist with our things around what to make sure is not included in evidence that is shared with a respondent. Those things would include like your address, your phone number, other safety concerns. So not looking to keep evidence away that is helpful to the case, just making sure that we're not putting your safety at risk when sharing information. And then sorry, just rolling through these. Can an accused party force the investigation to be formal? Yes, both parties have to agree to an informal process because the respondent is waiving their rights to when engaging in an informal process. So yes, both parties have to agree to an informal resolution. If they don't agree to that, the survivor can choose then to go through a formal process or can just drop it and not do it at all. Okay. We will also include the great question on, will our resources that we're making for students and advocates also have state-specific information? I will say that it will include some state-specific information. We are a very small team of folks and are looking to do our best in putting that forward. But our current playbook that we have, our state policy playbook, on each different section of the rule shows state laws that connect to those. So if you go to our state piece and you look at fair disciplinary processes, you can see at the bottom what state laws require these processes and what that looks like. So that's something to use in the interim, but we will be trying to include pieces of those state policies, but we definitely won't be able to include absolutely all of them. Let's see. Okay. Well, Know Your Nine create resources for students advocating their campus that are state specific. So like I said, we will have one information for you that's state specific. We also, like I said, are launching this Know Your Nine State Ambassador program. So Know Your Nine has looked through the rule and we've found what are all the loopholes that we can make state policy around, similar with our petitions that we're using on campus. Because like I said, while it's really great to have a petition and get your school to issue a good policy, often what schools do on paper versus in practice are very different. And so we'll be pushing for the pieces that we have around these sexual misconduct policies at the state and local level with an enforcement mechanism at the state level. So instead of needing to go to file a complaint with the Department of Education, you could, let's say, file a complaint with your state Department of Ed, or you could file a complaint with your state DOJ. Sorry, not DOJ, Attorney General. And that would then give you the ability to enforce these state mechanisms so that you're not just relying on the federal government to support your rights. So I would really encourage folks, if you're interested, to sign up to be a state ambassador or to join our campus action network so that you can pass these really strong protections at the local level. This is going to be a really important mechanism to protect survivors' rights in this wonky time where we don't have the department behind us. And also, all of these policies that we're working on right now are really great even if the rule isn't in effect. So let's say that the department, their rule is struck down by one of our lawsuits, then also we'll have these great policies in effect, even if the rule is in effect. Okay, the question around, some people are seeing that having an advisor with you means you can only have one person. I would say I've seen a couple different readings of this, and this is, I would say this. I have not seen one conclusive estimate on this in terms of if you can have just your person that is your advisor through cross and also a supportive person. I would say that the thing that giving the most hope is that some school policies are saying that someone can have their representative, meaning the person that is going to be conducting cross, and then also their individual supportive person that is providing emotional support throughout that process. And so if you are advocating at your campus, I would say I've already seen schools passing this policy and would encourage folks to do so as well. Our initial reading of the rule was that they could only have a representative that was doing cross, but that's not how many other folks have read it, and that's great. So I'd really encourage folks to push for having a supportive person with them as well that's not just engaging in cross-examination. And then if a school says that they'll provide an advisor, people are asking if that will be then an attorney that is present. There's no way to guarantee if your school is just saying that they'll have an advisor present that that person is an attorney. What I would say is that it's a great place for student organizing to focus, is making sure that if a survivor or respondent doesn't pick someone to represent them through cross, that the school would appoint an attorney to do that. There's a couple different ways that you could advocate for that at your school. One, that could be pushing for, if you have maybe like a law clinic that works on violence issues or freedom of speech or gender discrimination, that you could have maybe a MOU with that clinic to provide some support. Another piece would be looking at if your state legal aid could provide support to folks going through that process. And so that is definitely a space where schools can provide attorneys, and we would really say that schools definitely should provide attorneys. I know that I worked as an advocate with survivors throughout the Title IX process, and I am in no way qualified to do cross-examination. The idea of doing that is terrifying to me, so I can only imagine how folks are feeling now, and definitely would encourage students to push for an attorney to be utilized through cross-exam, and for those parties to have time with those attorneys before the cross-examination process, that they can become familiar with your case. Because anyone that works in civil court, especially domestic violence courts, know what it's like to have an attorney walk in an hour before a case and trying to catch up with that to provide them support. And so it definitely push for that. And great, thank you so much, Carrie, for sharing that. For folks looking for state-based or school-specific advocacy, Carrie has amazing recommendations for you, and she shared her email in the chat. And then I think that those are all the questions that I am seeing at this moment. If there are any other questions that come up, please feel free to send us an email at info@knowyour9.org. We're doing our best to answer all your questions and get you the support that you need. We recognize that this is a really confusing time for people, and that folks may not know what their rights are right now and what they need. If you're a student that is going through your current case or considering reporting, please feel free to reach out to us so that we can get you extra support through that process right now. And then also, like I said, please apply to be a state ambassador with Know Your 9 to push these policies, or to push for really proactive policies at your campus using our petitioning toolkit. And Know Your 9 is set up to provide technical assistance to student organizers to get you the resources that you need to organize on your campus and plan out strong campaigns. So if you're considering to sign up, or if you're considering organizing on your campus, then please reach out to us so that we can provide you some support. And I also, Layla, I'm happy to share a link for folks to apply. But I really want to thank you all so much for joining today as we try to get through as many questions as possible. I know that there's a lot of confusion, so I really appreciate your patience as we are working through all of this. And if there are any questions that come up, again, please feel free to send them our way. I'll be posting the link to the State Ambassador Program in the chat for everyone, and we will be sending out this recording soon. Thank you so much.